Greetings. Welcome to the second virtual seminar organized by the Disaster Law Interest Group of the American Society of International Law. My name is Dr. Kirsten Bookmiller of the Department of Government and Political Affairs and the Center for Disaster Research and Education at Millersville University of Pennsylvania. I'm also a co-founder of the Disaster Law Interest Group. On behalf of the Interest Group's co-chairs, current co-chairs, Mr. Arnold Pronto and Dr. Katja Samuel, as well as myself, I would like to thank the Center for making today's program technically possible. It's an honor and a privilege to introduce the seminar's featured presenter. Mr. Eduardo Valencia Ospina, hailing from Colombia, is a member from 2006 to 2021, first vice chair from 2017 to 2018, and current chair of the International Law Commission from 2018 to 2019, as well as the ILC Special Rapporteur on the topic Protection of Persons in the Event of Disasters from 2007 to 2016. He holds a Doctor in Law and Economic Sciences from Javeriana University, Bogota, with an LLM and pre-doctoral studies at Harvard. A longtime UN career official, he has been a member of the Codification Division of the Office of Legal Affairs of the UN Secretariat and of the ILC Secretariat from 1964 to 1984, elected Deputy Registrar from 1984 to 1986, and Registrar from 1987 to 2000 of the International Court of Justice. Fourth President also of the Latin American Society of International Law, and founder and editor-in-chief from 2002 to 2017 of the journal The Law and Practice of International Courts and Tribunals and the series International Litigation and Practice. He is also an active counselor in international law, including in international judicial and arbitral proceedings to the governments of Colombia and several other states from 2000 to the present day, and to the British law firm Eversheds, Frere and Cholmondeley from 2000 to 2010. Lastly, he currently serves as an arbitrator in cases before the International Center for the Settlement of Investment Disputes from 2016 to the present. It is now my privilege to turn over the seminar to Mr. Eduardo Ospina Valencia, who will be speaking on the protection of persons in the event of disaster. Thank you, sir.
Thank you, Dr. Bookmiller and Mr. Pronto, for this very kind introduction. I have been asked to speak about the final draft of the International Commission of the UN on the Protection of Persons in the Event of Disasters. At its 68th session in 2016, the International Law Commission adopted by consensus on second and last reading its final draft on the protection of persons in the event of disasters. It thus brought to a successful conclusion 10 years of uninterrupted work on the topic on the basis of 8 successive reports prepared by the Special Rapporteur, Eduardo Valencia Ospina, who is speaking. At the end of that session, the Commission submitted in its annual report to its parent organ, the UN General Assembly, the outcome of its decade-old consideration of the topic in a set of provisions couched in the form of draft articles, 18 in total, preceded by a preamble and accompanied by the corresponding commentaries. The ILC's final draft was transmitted together with the recommendation to the General Assembly, likewise approved by consensus, to elaborate a convention using it as its basis. For its part, the Assembly adopted on 13 December 2016 an autonomous resolution, our Resolution 141, by which it took note of the final draft, invited governments to submit comments on the recommendation that it served as the basis for the elaboration of a convention, and decided to include in the provisional agenda of its 73rd session in 2018 the corresponding item. The Assembly is therefore expected to take up this item in its 6th committee in the fall of this year. My presentation will then focus on the current state of play. In adopting its carefully evaluated consensual recommendation, the Commission is in effect inviting the General Assembly to move ahead and acknowledge all the significance that attaches to it. This is a recommendation arrived at by the Commission in full awareness of the reluctant attitude increasingly shown by the Assembly towards the elaboration of international conventions based on its final drafts on different topics. Such an attitude is tellingly reflected in the fact that starting in 2004, that is to say, during the last 14 years, not a single convention has been adopted by the General Assembly or under its auspices on any of the topics on which the ILC has completed and presented the results of its work in the form of draft articles. During the past 2 decades, the ILC has seized the assembly of 9 final drafts on a variety of topics, all aimed to eventually serve as the basis of international codification conventions. For its part, the Assembly has systematically reacted by repeatedly delaying, in one recent specific case almost indefinitely, taking action on the Commission's express recommendations that those final drafts be transformed into international conventions. This is an inefficient and uneconomical use of the legal resources and mechanisms at the disposal of the General Assembly for implementing its mandate under Article 31A of the Charter. It consequently calls for prompt and remedial action on its part through the determined efforts of delegations of states in the 6th Committee. The time to bring a halt to, if not reverse, that pernicious trend is now, when multilateralism, the laboriously built post-World War II concretization of international solidarity and cooperation, is being alarmingly subverted today by influential actors in the global stage, invoking an exaggerated notion of the national interest. But this is also a time in our contemporary history when, in spite of some notable though highly disturbing exceptions, the states continue to demonstrate their readiness to participate in legally binding instruments whose subject matter is closely related to the theme of disasters. Suffice it to mention in this respect the French initiative, working its way through the General Assembly, aimed at adopting a global pact for the environment, an international instrument which, like the ILC's final draft on the protection of persons in the event of disasters, is intended to establish rights as well as obligations. As explained in the terms of reference of the expert meeting convened for the purpose in Paris in the spring of 2017, and I quote, "This pact will be a single legal document containing the fundamental principles of environmental law. These principles are already stated in various declarations. However, existing declarations are somehow limited since they are not legally binding. By contrast, the Global Pact would be an agreement with legal effect. It would establish rights as well as duties and responsibilities." End of quote. In the same line of thought, it is particularly relevant to cite from the 2014 IFRC statement made during the Assembly's 6th Committee debate on the ILC's first reading draft on the topic. Addressing the question whether the draft article should be proposed as some sort of guidelines or as a draft treaty, the IFRC stated, and I quote, "We don't think that the option of presenting them as guidelines will be advisable. Such guidelines might be seen to compete with and hamper the progress in the implementation of existing guidelines on very similar themes, in particular the IDRL guidelines as previously negotiated and adopted by the state parties to the Geneva Convention. On the other hand, we think that strengthening the global legal framework by the adoption of an international convention would add a new element with the potential to further stimulate and enhance the work that has been accomplished through soft instruments, end of quote. The formalization by the General Assembly of the Commission's final draft on the provision of persons in the event of disasters, whose scope is universal, becomes today more than ever of capital importance to meet an urgent need of the international community as a whole, given the exponential increase in the variety, frequency, and intensity of the disasters afflicting all regions of the globe. As we are witnessing again today from Japan and the Philippines to the United States of America, disasters, whether natural or attributable to human action, do not spare any nation independently of their level of economic and social development. By definition, developed states are better placed than less developed ones to take by themselves more immediate and effective measures, preventive or remedial, when a disaster threatens to or does strike their territory. But in either case, international solidarity and cooperation, however different might be the degree of its manifestations, must play its constructive humanitarian role wherever and whenever the need arises. Cold figures alone can only give a pale vision of the magnitude of the losses that disasters create in terms of human lives and physical and mental health, mass displacement, property, livelihoods, and economic, physical, social, and cultural assets, as well as the environment. But thanks to technological advances in communications, each and every human inhabitant of this planet can become an immediate virtual participant in tragedies taking place anywhere in the world. Such has been the case most recently with the earthquakes, tsunamis, hurricanes, typhoons, storms, floods, mudslides, fires, volcanic eruptions, and the like, occurring in all continents, of which we are being made aware almost daily by the news media. In the face of the fundamental disruption of the function of the societies that ensues, affecting in many instances the very survival of sovereign states, international law cannot remain idle or continue to lag behind as it has traditionally done. Such was the situation at the start of this millennium when the IFRC could rightly emphasize in 2000, and I quote, "There is no definitive, broadly adopted source of international law which spells out legal standards, procedures, rights, and duties pertaining to disaster response and assistance. No systematic attempt has been made to put together the disparate threads of existing law, to formalize customary law, or to expand and develop the law in new ways," end of quote. Into this yawning gap, as the IFRC labeled it, stepped the International Law Commission in 2006, when on the proposal of the UN Secretariat, it included the topic protection of persons in the event of disasters in its program of work as one that reflected new developments in international law and pressing concerns of the international community as a whole, which is one of the criteria for the selection of topics it had adopted in 1996. As explained by the Secretariat, I quote, "The objective of the proposal was the elaboration of a set of provisions which would serve as a legal framework for the conduct of international disaster relief activities, clarifying the core legal principles and concepts, and thereby creating a legal space in which such disaster relief work could take place on a secure footing," end of quote. In elaborating a draft framework convention, the ILC has remained faithful to the original objective sought. That such a result could be achieved by consensus in a relatively short period of time is the clearest demonstration of the importance that the Commission as a whole attributed the outcome of its concerted work aimed at fostering the progressive development of international law. If today it can be admitted without reservation that international disaster law has developed as an autonomous branch of international law, that character owes in large measure to the ILC foresight in undertaking work on the protection of persons in the event of disasters, concretized in its final set of draft articles on the topic. Unlike other in the ILC's agenda, this topic was a truly novel one on which legally relevant practice was widely dispersed. In performing its task, the Commission found inspiration on three immediate legal sources of present-day international protection and assistance: international human rights law, international humanitarian law, and international law on refugee and displaced persons, and more concretely, on several instruments elaborated at the intergovernmental level and also by private institutions and entities. Such instruments, like those adopted by or under the auspices of the UN General Assembly, notably the seminal resolution 46-182 and the Hyogo and Sendai frameworks, or by the institutions of the Red Cross movement, the European Union, and the Institut de Droit International, among others, are in themselves, in effect, distillation of state practice. However, the great difference between those instruments and the ILC final set of draft articles lies in the fact that while the former are not binding, the ILC provisions are drafted in compulsory terms as rights and duties, so that they may become binding rules of international law, either as conventional or customary law. In any event, regardless of the decision that the Assembly might take at its 73rd session this year, some of the basic tenets of the ILC's final draft, while work on it was still in progress, have already influenced important developments in other legal political areas. I will mention just two: on disaster risk reduction and on arbitrary withholding of consent. Regarding the first area, mention must be made of Article 9, which enshrines the duty to reduce the risk of disasters and thus represents the acknowledgement of the need to cover in the draft not only the response phase of a disaster, but also the pre-disaster phase. In this manner, the Commission has provided the international legal foundation for a duty to reduce the risk of disasters, and in so doing, position itself at the forefront of the contemporary discussion on the legal nature and role of prevention, mitigation, and preparedness. At the same time, it has made a significant contribution to the further development of the tenets embodied in the Hyogo Framework of Action, which was achieved at the Sendai Conference in 2015. Quite significantly, the Sendai Framework for Disaster Risk Reduction 2015-2030 lists among its guiding principles two, the first and the third, which faithfully reflect the spirit and the letter of specific provisions retained in the ILC's final draft. As far as the second area is concerned, under paragraph 2 of Article 13, the consent of the affected state to external assistance shall not be withheld arbitrarily. As made explicit in paragraph 1 of the same article, consent is a fundamental pillar in the architecture of the ILC's final draft. In this connection, it is noteworthy that in two successive resolutions adopted in 2014 on the situation in Syria, the Security Council expressed first its regret inter alia that humanitarian aid delivery continues to be impeded throughout Syria, while recalling that arbitrary denial of humanitarian access and depriving civilians of objects indispensable to their survival including willfully impeding relief supplies and access, can constitute a violation of international humanitarian law. The Council then manifested itself, and I quote, deeply disturbed by the continued arbitrary and unjustified withholding of consent to relief operations, while noting the United Nations Secretary General's view that arbitrary withholding of consent is a violation of international humanitarian law and an act of non-compliance with the previous resolution. Accordingly, the Council proceeded on its own to take decisions which were simply notified afterwards to the Syrian authorities. Although these Security Council statements and decisions were evidently made in the context of a situation of armed conflict, they nevertheless add undeniable force to the applicability of the rule ultimately enshrined in draft Article 13, paragraph 2 of the ILC draft for a situation of disaster. The foregoing examples point in the direction and the manner in which the ILC final draft, the more so if it is made the basis for an international convention, can continue exercising in the future its central role, influencing in a constructive and forward-looking fashion the development of international law in specific areas closely related to disasters. Thank you.
Thank you, Mr. Eduardo Valencia Ospina, for those deeply insightful comments on behalf of the interest group members. I know that they will follow your observations with great interest. And I hope that I might indulge with you might indulge me rather, with one follow-up question. And that is, having been so closely involved with the process, literally from the very first days, do you sense in the ensuing decade plus the same sense of urgency that led to the beginning of this development and drafting process? Or have you felt, in fact, a pulling away of interest from the global community? What is the temperature taking at this point, and how would you kind of explain whatever the temperature is currently?
Well, thank you, Kirsten. Obviously, and unfortunately, in this area that is concerned with natural or human-made disasters, the sense of urgency to try to find solutions is enhanced and becomes very acute when a real catastrophe occurs. And this is very clearly exemplified when the tsunami that affected the Indian Ocean and a number of bordering coastal states caused havoc in all of these societies. The international community felt it had to react. It found out that there was no, as the IFRC put it, a comprehensive systematic legal treatment in terms of, at that time, the emphasis was on the response to a disaster, and the immediate reaction was to convene the Hyogo Conference, and then there were a number of other initiatives, including the submission to the International Law Commission by the UN Secretariat of this topic as one topic that needed to be developed and codified because it represented an answer to an immediate urgent need of the international community. But precisely the fact that we have become so aware of the disasters that occur daily in all parts of the world has perhaps made us very insensitive. And we have taken the fact that these disasters are now occurring, and there is nothing that we can do to prevent their happening, then we are beginning to perhaps react to them as if they are just another part of the normal life, however contradictory that could be. We are facing today, the East Coast of the United States is meant to be struck again by a mammoth hurricane. So will the Philippines of a mammoth typhoon. But perhaps in terms of casualties or material damage, it will not be as catastrophic as the tsunami of 2004. Mm-hmm. And consequently, we'll just say, well, it's another storm. We had one last year and the years before, and it's another typhoon. And we have, of course, it affects countries like Japan and the United States that are able by themselves to take all the necessary measures to respond to the disaster, but it affects countries like the Philippines that are less so. Mm-hmm. And it is irrespective of the fact that most developed states could respond more quickly and more efficiently to this type of disasters, or try to prevent and reduce the risk of disaster. Disasters affect everybody, regardless of levels of economic and social development, and there is need for then triggering the solidarity and cooperation that should bind the international community when there is this kind of danger and realization of a danger that affects all us. So I don't think that we will need another tsunami to create again an interest in developing the law. I think we should be more mature than that and see that the trend in the last, since 2004, 15 years, has been a tremendous increase in the frequency, the intensity, the economic, social, and of course human losses of disasters. And perhaps think that if we don't do something about trying to legally create the system that would facilitate a response and a preventive measure for the future, then we are ourselves condemning ourselves to just being the victims of this phenomena in the future. And it's not only disasters as such, as we have defined them in our topic, but related topics like climate change or displacement and etc. And the move in those areas, in spite, of course, of some notable exceptions, is towards trying to precisely not only strengthen the existing instruments, but elaborate new instruments with binding effect. And this is where, since disasters on many occasions arise out of climate change problems and so on, there is a connection. And I feel very optimistic. We see the demonstrations in French cities and all over towards doing something about climate change. And I think we can feel that the same should be the attitude towards this more specific instrument dealing with disasters. So I remain moderately optimistic, and disasters are happening there. All we have to do is open the TV, and we cannot ignore that.
Mm-hmm. I believe I can speak on behalf of my colleagues within the disaster law field, specifically and more broadly in disaster management. Complacency remains all of our shared concern, and maybe it's incumbent upon us to think about how we recalibrate that message, as you said, that we've gone from the shock to now it being so, getting to the point where we may think that there's nothing that can be done about it. And of course, nothing could be farther from the truth. Mr. Eduardo Valencia Ospina, thank you so much for spending and sharing your valuable time with us. On behalf of the Disaster Law Interest Group, on behalf of Mr. Arnold Pronto, Dr. Katja Samuel, the co-chairs, and myself, we again appreciate the insights shared. I know it'll be of great interest to all of our members. Thank you.
Thank you very much, Dr. Kirsten and Arnold and Katja, for giving me this opportunity. I feel very honored and I feel very reassured when I see that people of your caliber are sharing in this common enterprise with me. Thank you very much.
Thank you.